Mr. Jones, I'm going to tell you one thing. Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I? It's only 3 years.
When I'm talking, you do not talk over me. Do you understand that? Because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years. I don't need
Mr. Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do.
All right, folks. Today's case is a wild one, and not in a good way. We're taking a close look at a man who proudly carries the label of sovereign citizen, someone who believes the law simply doesn't apply to him. And trust me, his courtroom. Behavior reflects that bold, arrogant, and completely detached from reality. Now, here's where it gets even more unhinged. This guy is already serving a 4-year sentence for armed robbery. But instead of lying low and doing his time, he just racked up even more trouble, facing an additional 3 years after allegedly assaulting a corrections officer while in custody. That's right, he's in prison and still finding ways to escalate things. It's honestly baffling. He walks into court with this bizarre confidence, like he's not the one on trial, but the one running the show. And it makes you wonder, is this someone who genuinely believes the nonsense he's spouting? Or is there something deeper going on mentally? The courtroom energy is tense from the moment it starts. The judge, the attorneys, even the staff, all seem like they've dealt with this guy before, and you can feel their patience running thin. This isn't just another inmate with an attitude problem. This is a person who seems completely disconnected from the reality of his situation. So here's the big question. Is this behavior a product of genuine belief in the sovereign citizen ideology, a mental health concern, or just pure recklessness? Let me know what you think in the comments, because cases like this really make you question where the line is between defiance and delusion. All right, let's go ahead and dive in, because this hearing turns heated, fast, and you're going to want to see how the court tries to bring this guy back down to earth.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials. I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you
3
won't.
years, man. It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry.
Cool.
It's not cool. You're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
We're only 3 minutes in, and this man is already trying to get his case dismissed. It's honestly hard to take seriously. If these sovereign citizens truly believed the courts had no authority, you'd think they wouldn't show up at all. But instead, they arrive on time, follow courtroom procedures, and then try to argue that none of it applies to them. What exactly are they hoping for? That the judge will just throw out the case and say, "You know what? You're right. None of this counts." That's not how the legal system works. I really wish the judge would clearly explain that jurisdiction isn't based on someone's personal beliefs, it's based on facts, like where the crime happened and what the law says. But these individuals often act like their opinions can override legal reality. What do you think the goal is here? Drop your thoughts in the comments. I personally feel like he's just trying to drag things out and stall for time. Let's get back to the hearing and see how this plays out.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what I
Ms.
gotta
Martin
do.
does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is
We'll
what
see
I'm
that,
doing
but that
right
will be
now.
tested.
I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. Do you want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
That's correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
I
Are
don't
you
understand
aware of
the
any?
question.
Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume,
Correct.
at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand
Correct.
that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right.
So now, according to this man, the judge is somehow the one breaking the law while he claims to be the only one following it correctly. The irony here is pretty striking. He doesn't actually understand the law, yet he's trying to argue that it judged someone who's spent years studying, practicing, and interpreting it to somehow doing it wrong. It's honestly hard not to shake your head at moments like this. You can tell he's been influenced by a few internet videos and now believes he's an expert. Meanwhile, the judge clearly knows what's happening and remains calm through all the noise. It's just strange, too. See someone so sure of themselves while being so far off base. There doesn't seem to be much reflection or awareness on his part, just a lot of loud claims and frustration with the court. It makes you wonder, is this part of the sovereign citizen mindset, or is something else going on here? I'd love to hear your thoughts. Drop a comment down below. Let's jump back into the hearing and see what happens next.
There may be possible mitigating circumstances. Do you understand that?
Huh? Nah, nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3
this.
years, man. That's
I'm sorry?
3 years. That's nothing.
Let me ask you. Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental. It will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay? But you understand what I'm telling you.
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Oh, can I get a few minutes? I use the bathroom anyways.
A few minutes for what?
To use the bathroom, think about it. Make sure this is what I want to do.
Take him to the bathroom.
That wraps up the first hearing, but, believe it or not, this man isn't done yet. He's back for round 2, and things are about to get even more intense in this second hearing. He completely loses his temper over what he claims was a scheduling-era small slip of paper with the wrong date. But instead of calmly addressing the issue, he explodes in frustration, taking it out on the judge in a way that crosses a serious line. This is where the situation really escalates, including a direct threat toward the court. Let me know in the comments how you think the judge handled the first hearing. Was it fair? Too lenient? Now, let's dive into the second part of this case. Only gets more heated from here.
Can I say something real quick, Your Honor? I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your
So
security of this.
how I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen because for the record, there's a skirt or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
It almost feels like the more frustrated this man gets, the worse his microphone sounds like his anger is somehow interfering with the audio. It's becoming hard to hear, and honestly, it's tough to watch. This kind of behavior has unfortunately become pretty common in sovereign citizen cases. Poor video quality, it's bad sound, and arguments that are completely disconnected from reality. What's really surprising is how calmly the judge is handling it all. Most people would have run out of patience a long time ago. Credit where it's due, this judge is staying professional, even as things continue to spiral. And here's what makes it even more baffling. The man doesn't even have his video turned on. He's shouting, arguing, and even making inappropriate comments, all while hidden behind a blank screen. At this point, many judges would have called for contempt, and honestly, it's hard to understand why that hasn't happened yet. What do you think? Should the judge have taken stronger action? Let me know in the comments. Now, let's get back to the hearing and see how it all plays out.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of.
All right. Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this? Why don't we do this, Mr. Jones? Let's start. Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
I use the bathroom because I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him, let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Miss Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Miss Martin
No,
to...
I don't want her near me, around me, or nothing. She can leave.
All right, sign the
She's good
form
to
in
go.
front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need
Mr.
no
Jones, I
help.
don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason,
Mr. Jones, read-
of representing myself was because I didn't trust the lady. That was
Okay,
the whole purpose of
she's
that.
not,
But she's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself-
I'm removing her. Was for that. Was for me to be able to represent myself.
you will be. Sign the form.
This
Read
form
it.
was already signed. You
All
already
right,
seen my
read-
signature. You already
I'm
asked
sorry,
me
I
my
misspoke.
signature. You see my signature was on that sheet. You already said it was there. What are you talking about?
I had to laugh a little when he threw in that final comment about having the court papers sent to his home. We all know what that usually means. He's probably setting the stage to claim he never received anything. It's a classic move in sovereign citizen cases: deny, deflect, then act surprised when things don't go their way. Honestly, if folks spent even half as much time learning how the law actually works as they do arguing against it, they might avoid a lot of these problems in the first place. But you really do have to wonder, how do people convince themselves that this logic makes sense? It's like there's a guidebook out there titled How to Lose in Court in 10 Easy Steps. On a more serious note, it raises real questions about mental clarity. To truly believe you can just opt out of the law? That's not just Confucians. Deep denial. It's strange to watch, even a little sad at times. If being completely disconnected from reality were a legal defense, a lot of these folks would be the first in line to use it. Anyway, what did you think of this guy? And more importantly, how do you feel the judge handled the situation? Personally, I think the judge showed a lot of patience, but part of me wishes he had issued a contempt charge. Just to draw a clear line. If you enjoyed this breakdown, don't forget to like, subscribe, and stay tuned for more court cases like this. Thanks so much for watching, take care, and we'll see you next time.
Martin will stay in the courtroom as standby counsel. Other than
I'm
that, are we
objecting
ready
to
to...
Miss Martin standing by
Mi-
counsel.
Mr. Jones, I'm going to tell you one...
Counsel.
Mr. Jones, I'm going to tell you
I'm not allowed
what...
to object. I'm my own counsel now. I'm allowed objecting, ain't I?
Then you say the word objection.
I did. I said I object.
Yeah,
How am I
what are you
supposed say it?
objecting to?
I'm
I
objecting to
removed-
Miss
I've-
Martin standing by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her, was to represent myself, because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her wasn't
right, stop.
based on...
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your Honor.
All right, bring them down.
Well, we didn't end up getting footage of the jury trial, and that's because, as many of you probably know, jury trials aren't allowed to be recorded in most cases. Don't worry, we've still got the outcome. According to court records, this guy ended up doing exactly what he said he would. He represented himself, and it played out just as disastrously as you'd expect. The jury didn't hesitate. He got hit with the full 3 years. No reductions, no leniency. Nothing, and just to be clear, those 3 years are consecutive, not concurrent. That means instead of serving them at the same time as his existing sentence, they're added on top of the 4 years he's already doing. That brings his total time to a solid 7 years behind bars. And you know what? I think that's why. He was so strangely calm about it in court. He probably thought the new time would just overlap with the old one, like some kind of legal 2-for-1 deal. Well, surprise, that's not how it works. The judge made it crystal clear. He's serving every single day of that sentence. Honestly, it's wild. The confidence, the arrogance, the total disregard for legal strategy, all of it just imploded. In the end, it's like watching someone climb into a hole they dug themselves, then act surprised when they can't climb back out. Now I'm curious, do you think he realizes yet what just happened? Or is he still sitting there, completely unaware he just tacked on years to his life behind bars? Maybe he's okay with it. Maybe he's already planning his next courtroom disaster. Who knows? One thing's for sure, he's going to have plenty of time to think about it. In all seriousness, this case was one of the most bizarre and frustrating ones we've seen in a while. Whether you feel sympathy, secondhand embarrassment, or just disbelief, it's hard to forget a guy like this. So what do you think? Was this just delusion in action, or a guy who never really had a shot to begin with? Drop your thoughts in the comments. I read every single one. And if you want more breakdowns like this, don't forget to like, subscribe, and hit that notification bell so you don't miss the next one. Thanks so much for watching, and as always, stay sharp. Stay safe and take care.